There's a lot of twists and turns when it comes to the process to remove the Chief Justice. It is currently ongoing, but it has become a very fascinating process indeed, a historic one, unprecedented. And I guess the democracy is all better for it because we're going through this process. So by the time we're done, whatever the outcome, our democracy will be better. There would have been several decisions at the Supreme Court just in the course of this process alone that we'll learn a lot from. There's been twists and turns today. It has been one of the most consequential days as far as the process is concerned. And I need to bring that to you as you sit down to relax, to appreciate what is the biggest story of the day. And it's undoubtedly this story. So far, we counted at least 5 suits so far, at least 5 suits on the matter so far. 2 of them were decided today. And just when the decisions were handed down by the Supreme Court on those 2, a third one emerged. So in one day, 2 decisions by the Supreme Court, and then 1 additional suit. That third suit that was filed today, just close to the end of the day, just about 5 p.m., when those who were pushing it filed it, we got to know for the very first time that the Chief Justice herself has now taken a suit at the Supreme Court. A court that, until very recently, she was the boss of. I mean, she really was the boss of the judiciary until she was suspended. She's now taking a case to the Supreme Court, asking her colleagues to now make a decision. Remember, this is a very fascinating twist indeed to this whole scenario. Now consider the Chief Justice, who until very recently was the boss and empaneling judges. All the judges who have been sitting, she was their boss, and she told them what to do, and they did it. Which cases to hear, and they had it. Which cases they should sit on, and they simply did it. Now, the acting CJ will now have to empanel colleagues to hear the case of Justice Torkornoo. And this is very fascinating. This is the first time that she herself is the plaintiff in the matter. She herself, the Chief Justice, now a plaintiff in the matter before the Supreme Court, where she used to sit in judgment of others. Others are going to be sitting in judgment of her. That's a fascinating story tonight, and there's a lot to unpack here because of what she's asking for. A lot of them very fascinating. Many of them, I must say, majority, we are used to that. All the 5 suits I've talked about are very similar, largely asking the same things, and you wonder, but why? You go, you lose, you go again. Essentially asking for the same relief, making the same arguments. But there are a few additional reliefs that she's asking tonight that are new. We'll go to that when we sit down for a conversation. But she's taking this case against the Attorney General, Justice Poaman, who chairs a committee investigating the matter, and Justice Adibu Asiedu, who is the other Supreme Court judge on the committee. Daniel Demelebo, you know him, the former Auditor General, who is also a civilian member of the committee, another member of the committee who is not a judge, Major Flora Adulogu, and of course Professor James Jisa were all members. So she's actually challenging the committee's mandate to say that they shouldn't be allowed to go ahead. And we'll get into her reasons for that pretty shortly. A few of them, there are like 16 reliefs she's asking for. I can't tell you all, but let's go to the essential ones because you can summarize them into blocks, right? Because a lot of the reliefs are repeated, quoting different laws to back it. But the first fundamental one, the new one, is the fact that she's asking that the hearing should be held in public. That there should be a public hearing as far as the proceedings are concerned. That we should take cameras into the room and so we can all see what is happening there. As a journalist, I would love that. It will make for some great drama, but this is a constitutional matter. It isn't one that you can just decide not to do. She's waiving her in-camera rights, right? Is it her rights to waive, or the Constitution really gives no room to maneuver on the subject? Our lawyers will join us for a conversation on that. And then she's also saying that the prima facie determination that was done was improper. Why? We'll see when we sit down to expand on the matter. And then also, she's also saying in the reliefs, as part of the reliefs that she's put before the court, that the members of the committee, all of them, including as I mentioned, Scott Palmer, who's the chair of the committee, shouldn't sit. Why is he asking that? Because he had been a judge in another matter and had ruled in favor of that individual who now is a petitioner in the case to remove the CJ, right? And so he should be disqualified from sitting in judgment on that particular case. So that's a very fascinating one indeed, too. We'll get to look at everything else that she's asked for. And then there are two cases today, as I said, that have now been decided by the Supreme Court. All of them asking the same thing, trying to stop the process and get her suspension suspended, right? In both cases, the Supreme Court decided 4-1 that there was no merit in the release that they're seeking and the evidence backing that. So all of them have been dismissed. We're waiting to see when this latest one will be heard. But another fascinating thing for me that I look for today, there's a drama of it. When the other case was called, the Chief Justice is a lawyer for the very first time was in court. And questions were asked, was the Chief Justice herself there? Because obviously this is a matter that she is the main character in. And she wasn't, but the husband was there representing her. I mean, how fascinating would have been for her to now come into a court that she used to sit in judgment and she was a boss of, to now appear before her colleagues and to be judged, right? My guests are joining me. All the twists and turns. Fascinating indeed on chartered territory. We're going to unpack all this. And then we are learning tonight that on this particular matter, the Chief Justice has hired the former Attorney General, Godfred Yeboah-Dame, to be her lawyer. Again, another major twist. It changes a lot for those who watch this very closely, right? Because factually, the president nominated her, subsequently became the Chief Justice. There's no way the president would have nominated her without an input from the Attorney General, Godfred Yeboah-Dame, who was there at the time. And so that raised a lot of questions. So there's a conflict of interest, possibly. He, obviously, having played a role in the Chief Justice's appointment, is interested in keeping her there, and that's the accusation. And that many also say, because she now has gone for Godfred Yeboah-Dame, then clearly now puts it beyond doubt that she may be aligned now, or she is indeed aligned to the New Patriotic Party. Godfred Yeboah-Dame disputes that and says, well, but look at the petitioners. They have lawyers who are known to be affiliated with the NDC, and they have taken their side. They've pitched their tent in the camp of the NDC. So yeah, why not? But then that raises fundamental questions about the politicization of this entire process, which should have been purely a constitutional matter. My guests will weigh in after this. And thanks for staying with us on PM Express. It's always brought to you by Syntex Tanks, our academic time newspaper and Pepsodent Cavity Fighter. I want to bring in my guest now for a conversation. Joining me right now is Kwekwan Sarsari. He is the former rector at the Ghana School of Law. Also, he's also with the Mount Crest University. John Darko is a legal counsel to the minority in Parliament. Abraham Maliba is a former director of legal and NDC, acting director general at the National Road Safety Authority. Kwekwan Sarsari will join us pretty shortly because I really wanted to hear his thoughts on one fundamental relief that the Chief Justice is asking for. I want to bring him in now, Mr. Sarsari. There's one interesting relief that the Chief Justice is praying the court to grant her. She says she is entitled to waive her right to the in-camera hearing, if you may. The Supreme Court, the Constitution is clear that this process must be held in camera. But she says that she believes there's a case to be made for a public hearing. What do you make of the argument? Hello, Mr. Sarsari?
Yes.
Yes.
Good evening.
I can hear you. Can you hear me?
Hello? Yes, now. Yes.
Yes. I'm asking you what you make of the Chief Justice's plea to the court today in this fresh process she filed, asking for a public hearing and that the right to an in-camera hearing can be waived.
Well, she's trying to exercise her discretion one way or the other. Now, the stumbling block is that the Constitution does not allow a procedure other than in-camera hearing, and therefore, this is not one of the instances where the Supreme Court can waive that procedure. I think that it's so entrenched that for now, unless it is amended, for now, it has to be held, the proceedings must be held in camera.
Okay, Abraham Oliba, weigh in on this for me. Do you agree with her?
That it should be waived?
No,
I do not.
Sorry. Forgive me. I'm actually forgive me just a second. I'm actually asking that of Abraham Amale, but stay with me. I'll come back to you pretty sure. I'm just running this by the rest of my panelists. Abraham, what do you make of that request for this hearing to be in camera?
Evans, the request is to enable us because the Constitution provides for how these matters are to be dealt with. And so you have no discretion to decide to, as it were, breach the Constitution because you feel that you want to waive that right. That right, if it's granted, amounts to she and the Supreme Court colluding to breach the Constitution. And I think that is why the Supreme Court would have to guard against.
Okay. So stay with me. I want to bring in John Darko. John Darko, give me your own thoughts on this.
All right. Thank you. Good evening to your viewers. I think it's very interesting that when it suits us, we think that the Constitution is so entrenched, and when it doesn't, then we believe that we can step aside the constitutional provision. Well, in this country, less than 2 weeks ago, when the president left the country, when he knew that the Speaker of Parliament was not in town, the Vice President was not in town, the constitutional provisions and the case of the same Masari and Attorney General, the Supreme Court had interpreted the provisions so clearly that you couldn't leave the country without swearing in either the Speaker of Parliament to act. But the President left the country breaching the constitutional provision, violating the constitutional provision, and we didn't hear our brothers, or at least the panelists here, condemning the breaching of the constitutional provision. And so sometimes I wonder why we always want to do this to ourselves. We want to treat the Constitution, as if it's a convenient document that
is there a constitutional is there a constitutional basis to waive that clause that says this process must be held in camera?
So look, if you look at Article 146(a)(8), which talks about the fact that the committee shall sit in camera, I think it is the basis for which my co-panelists are saying that the provision is so clear and that we cannot do anything about it. But we know that this same Supreme Court, our Supreme Court, has interpreted SHA, okay, because we are talking about the fact that the Constitution says it shall be in camera. The Supreme Court has interpreted SHA to mean not that provision may not necessarily be binding. I mean, in the Akufo-Addo and Mohammed's case, we know how the Supreme Court interpreted SHA. And so the fact that Article 146(8) says that the whole act shall be held in camera does not necessarily mean that we cannot interpret that to mean that this should be open to the public. Look, this is a matter of public importance. And if you look at our provisions, Article 281, this is more like a public inquiry. And the law is very clear that when it comes to public inquiry, unless it's going to be against public order, public morality or public safety. These kinds of hearings must be in public. And so I don't think that it is so rigid, so difficult that we cannot grant that request. Look, I think that it's in the interest of justice. The people of Ghana deserve to know what is going to go down in this historic action that has been taken by the president. Look, we've seen the Supreme Court at least opening up our courts to camera, to public. We know in the two election petitions, the court decided that they will hold the thing in public, even though our courts, are not allowed to broadcast trials, in public. But because of the interest the public had in the election petition cases, the court made room for this public viewing to happen. We've seen that happen in other countries. I think that if you look at the Anita Hill case, you see that until that hearing, the Senate hearings were always, in camera. And so it is not too difficult. And if you look at 1468A, again, my position on the law is that the fact that the provision says it shall be in camera doesn't mean that we cannot interpret that to mean that we can have it in public.
Abraham Maliba, John Darko has a point, is it not, that even if you just go beyond the constitutional provision itself, what do you lose if you open up this committee hearing to the cameras? In fact, don't you rather gain transparency? You actually gain a bit more openness to the process, and that citizens can then follow, and you'd then rule out the possibility that this may be misconstrued in the eyes of the public. This is good for democracy, is it not?
Democracy is different from what the law is. The law is not democracy. Democracy is not a law. These are two different things. Good governance is what you are talking about, but the law is the law, as its embattled Chief Justice said. Clearly, the Supreme Court is under the Constitution. The Supreme Court is not above the Constitution. The Supreme Court can only do what the Constitution says it can do. The Supreme Court cannot do what the Constitution doesn't say it can do. And so, if we are advancing the argument that even though the Constitution stipulates how these matters are to be dealt with and says that the hearing must be in camera, but the Supreme Court should go beyond the Constitution, then we end up not having a Constitution at all. And we can't just say that we should allow the Supreme Court to do what it likes.
But what real purpose does it serve to have this in camera when the person who is accused says, I'm ready to waive that?
I want to believe that the framers of the Constitution were of the view that such matters, because of the position of the Supreme Court, there are some information, when it is leaked, may have some negative impact on the country. Probably matters of national security, the same things that my colleague is talking about, public health matters. We don't know where it will touch. We don't know which of our life as a country that this may negatively impact. And so the framers of the Constitution, I'm just thinking for them, may be thinking that because you don't want to spill those things in the public domain, it should be held in camera. The issue that in the past, the Supreme Court, or is it the courts, did not allow cameras into the courtrooms, but now we have it, is different from this. In that situation, we didn't have provisions proscribing the use of cameras in our courts. It was just a practice, and so you could easily do away with the practice. But in this one, it is clearly stated, and you cannot. You could have as well said, okay, the two justices should also sit. We should go and bring justices from other countries Or we could say, but the Constitution has stipulated how, the way and manner in which this must be done, and you have to respect it.
But Council, if I may just chime
Yes,
in,
please.
you see what is happening here. What is happening here is not going beyond and above the Constitution. I think that what is happening here is just interpretation of Article 146A, which says that the committee shall sit in camera. Okay, so just interpreting that provision, and we know, like I said in the Akufo-Addo and Mohammed's case, the 2013 case, the Supreme Court interpreted SHA to be permissive. More or less, SHA is not mandatory and that it could be permissive. So we can say that the fact that SHA is there, the fact that 146 says SHA may mean may. And so it is not necessarily binding and that they can waive it. Our Supreme Court interpreted SHA in 2013. They said that it doesn't necessarily mean that SHA is compulsory and that we may interpret that to mean may. And so let's instead of SHA, let's put may there, and you see that it will read nicely, and the Supreme Court can easily say that, okay, we will give you the right to be heard in public. And so there's an option. We cannot say that there's no option because of the way 146A is, crafted.
No, that type of interpretation is not done in just, where may is interpreted to mean shall and shall may. No. In situations where a person's rights would be affected, that is when you would interpret may to mean shall. So, for instance, if you say you may,
case,
after a committee hearing,
somebody's right will be affected?
After a committee's hearing, you may give Evans Mensah the proceedings of the hearing. Then you say, oh, it says may. But you know that Evans Mensah needs that report to mount a case in court. At that point, the court will say it's a shall. This one, how would the hearing in camera affect her rights? How would that affect her rights?
Of course. I mean, the people of Ghana need to know,
It's not about
wait, my brother. She's been accused of so many things, okay? And already we all know, you and I know, that the petitions are in the public domain. And so people want to see how this will be proven before the committee. People of Ghana, for whose, interest and this justice, is done, need to know, because this is, and let's be careful. This is the first time one head of the arm of government is being removed. The people of Ghana deserve to know. They want to follow what is happening. And she herself will want the people of Ghana to know her position, because she's been disgraced with all these petitions. She wants to prove her case in court. I don't think that.
John Darko, stay with me. Let me bring in Asasari. Mr. Asasari, is it her right to waive?
Hello?
Yes. Is it her right to waive?
You mean the lady Chief Justice?
Chief Justice, yes.
No, the Constitution doesn't put, the applicant, to an election to elect whether to waive or not to waive.
She's the accused in this case, and she has everything to lose, right? So you think that this clause was put there in the interest of natural justice and also in protecting the rights of the Chief Justice in case anybody triggers it. Isn't that her right to then waive if she doesn't want to?
No, the answer can be found in Article 125. It says that even though citizens' participation in the administration of justice must be encouraged, it is subject to the Constitution, and therefore the independence of the judiciary is itself subject to the Constitution. That's a clear language of Article 125 of the 1992 Constitution. Now, remember, Kofi Kumado once said that democracy is not synonymous with constitutionalism. So the two are different. Yes, democracy, but the Constitution, speaks in peremptory language sometimes when shall is shall. Then thirdly, I think this is one of the instances where Atta will describe, the operators of the Constitution, as not only subject to the Constitution, but also to be, constantly reminding themselves that the governance institutions that are being created by the Constitution are to aid them to behave themselves, right from the presidency to the media practitioner. So the Council of State is there, it has been designed to aid the president, to behave himself. In like manner, the Judicial Council has been established to aid the Chief Justice, successive Chief Justices to behave themselves. So if the incumbent Chief Justice has a problem, her first port of call will be to seek counsel, wise counsel from the Judicial Council. I don't think that has been done. And therefore, all these things that the Chief Justice and the lawyers are simply amount to a provocation of the committee. Their acts are designed and have been skewed to provoke the members of the committee into doing things that will turn out to be unorthodox, unconstitutional. So I would deem the whole thing, to be a provocation of the committee. The CJ removal process now has been so engrossed in politics that the whole thing is political. So issues of transparency, legality, and all that.
I may have lost him there, but he just
I have to uphold the Constitution, please.
Yeah, I mean, and you touched on the politicization of the process, and I want to bring in John Darko. John Darko, today we learned that in this process that the Chief Justice has commenced at the Supreme Court, her lawyer is going to be the former Attorney General. Was that a prudent move, considering how politically exposed, and putting it mildly, the former Attorney General is, and the former Attorney General who was instrumental in the process of nominating her to the bench, to the Supreme Court as a Chief Justice, not to the Supreme Court, but as a Chief Justice? Was that a prudent thing, considering how politically charged this whole process is?
Well, I mean, so this whole thing has indeed been political. And from day one, it has been political. The President of the Republic, before he became president, had promised his NDC base. He had promised the NDC lawyers at a meeting that when it comes to power, he will make sure that he will reset the judiciary. And we have noticed that the first set of resetting the judiciary is to remove the Chief Justice. This is the first time, I believe, in the history of this country where within the first 4 months of an administration, seven Supreme Court justices have been nominated. President Kufuor nominated his first Supreme Court judge 2 years after he came into power. Nana Akufo-Addo nominated the first 2 years after he came into power. President Mills nominated the first one. He did that one also early, but it was just one person, I think, within the first 5 months. This is the first time we've seen 7 Supreme Court justices nominated, or nomination to the Supreme Court justice within the first 4 months of the administration. This is politics at play. And I think I've made that point clearly, that what is happening here, we can always look at the Constitution to, as it were, cover the politics that is happening.
Are you suggesting that in the decision to select or choose the services of Godfrey Dame, the Chief Justice is aware of that, and so she's aligning with the MPP side in Godfrey Dame representing her?
Well, those are your words. I've never said that.
No, I'm clarifying. Only because when I asked the question, you went to make the point about politics.
Yes, because this is politics the president has engaged in. He's political. In fact, the last time I met one NDC panelist on CTFM, he said that what the president is doing is to balance the judiciary by appointing 7 nominees to the Supreme Court. He was balancing the court. That is an advisor to the vice president. He said that.
I guess my question
so
to you
I'm saying that.
What has that got to do with Godfred Dame representing her?
So I'm saying that this is politics. And so for me, any person who wants to choose a lawyer is entitled to choose any lawyer of his choice or her choice. But it is the politics. While we brought in the question of politics, I needed to remind you that it is the president who is engaging in this political vendetta. It is the president who promised the base of his party that he was going to change the judiciary. It is the president and his people. Look, the chairman of the NDC said that the chief justice must go. The chairperson, in fact, he said the top hierarchy of the electoral commission must also go. That is a city. He has said that. So what more do you need to know? That this is all politics and that they are playing the politics so well. They want to politicize the Supreme Court.
What about the Chief Justice's move? Is it a political move then to get Godfred Dame to represent her?
The Chief Justice is entitled to appoint any lawyer of her choice.
But couldn't the choice be more neutral? I mean, isn't this choice a fatal one politically?
I believe that the Chief Justice is entitled to appoint a lawyer of her choice.
Amaliba, what do you read into this?
Well, we have all known that, but let me indicate that one of the reasons why the hearing must be in camera is also to protect the petitioners. And so, much as you are looking at the person who has been petitioned against, you also look at the...
What kind of protection do they need?
So,
if you may want to shed light on that, what kind of protection do they need?
So you need to understand that one as well. But moving forward, it is not a secret that the MPP have been behind the Chief Justice. I'm saying this because during her tenure as Chief Justice, she has protected the MPP. Elsa, can you explain why a former Attorney General would have been winning all cases and immediately he leaves office, he begins to lose cases? So we've always known that this Chief Justice, whilst in office, had protected the government of the day, the Nana Akufo-Addo administration. And so it will not be surprising to have lawyers of the MPP, and we all saw the kind of defense and the advocacy that Afenyo-Markin is doing for her. We know the relationship that exists. So it's a small country. We know each other. We know exactly what we stand to benefit from some of these things. So don't be surprised that some of these applications that you are seeing in court are actually having MPP lawyers behind them and trying to put spokes.
I mean, Amaliba, keeping them honest. The petitioners also came before the committee, as we've now learned, with lawyers who are aligned with the NDC. Justice Shikata is one of them.
Yes, but there's a policeman who is an NDC person. I'm not sure you know the political persuasion of Vomawo. I'm not also sure you know the political persuasion of Thaddeus Osori. But yes, I've heard John Darko talk about the former president. The former president never said that he was going to remove the Chief Justice. What the former president did, and I was the director of legal at that time, was that he encouraged the NDC lawyers to take up positions on the bench. And that has nothing at all to do with the current appointments. If the current appointees were coming from the NDC stock, those who were at Ada, if it were Adawudu, yes, then you can say that what he preached is what he's implementing. But these are seasoned judges, and Don Darko is aware of the caliber of people like Sir Dennis who have all been marking time and are now being elevated. So we need to look at these things dispassionately. It just has nothing to do with balancing the court. It has everything to do with ensuring that persons who were overlooked in the last administration are made to occupy positions in the Supreme Court.
I mean, but what you really want to say is that persons who are aligned with the NDC who had been overlooked. That's what you really want to say.
I don't even know that.
No, I'm saying that, Evans, I'm saying that when the former president spoke about NDC lawyers taking up positions, these 7 judges were not in that audience. And I'm saying that if the president had appointed somebody like Adawudu, who was in the audience, or myself, then you could make that argument that John Darko is making. But these promotions from the Court of Appeal to the Supreme Court is just a natural progression of judges who were overlooked under the past administration.
Anyway, we digress. I mean, that subject is significantly overflogged. I know that you guys have talked about this, and MPP you defended it. But to the substance of the conversation, I want to go back to Ansah Asare. But before that, John Darko, before Godfred Dame took up this job to be the Chief Justice's lawyer, the suspicion was there that the Chief Justice was doing the bidding of the MPP while she was there as a Chief Justice. Aren't you concerned about the optics that this confirms? That, goodness me, Godfred Dame, as has been suggested, now represents her and confirms that she's indeed all along been in bed with the MPP. You're not concerned about that optics at all?
Yeah, I mean, I'm surprised to hear that the Chief Justice was doing the bidding of the NPP.
I mean, that has been the accusation from the NDC side.
And look, like I said, I believe that when it comes to who represents you, anybody is entitled to allow office of her choice. You clearly showed how Chachu Chikata is now the lawyer for one of the petitioners. I mean, I don't have any problem with that because, of course, we know Chachu Chikata as the heart of NDC's legal team. He's leading them. I don't have any problem with it. He's entitled to earn his fees. And Godfred Dame is working. He's no longer the Attorney General. And if somebody will consult for his service and he deems it fit to take it, I don't have any problem with that. So in terms of who comes in as the legal rep for either the petitioner or the Chief Justice, I don't have any problem with that at all.
I mean, I'm so sorry.
Yes?
And you are a lawyer, and lawyers also strategize. From a purely strategic point of view, was this a monumental strategic miscalculation on the part of the Chief Justice to call Godfred Dame up and make him her lawyer?
Well, it has only lent credence to the fact that the whole constitutional matter is now engrossed in political controversy. And as you can see from the contrasting legal representations, Godfred Dame and MPP like-minded persons appearing to represent the Chief Justice, while my legendary lecturer, Chachu Chikata, my good friend, Sadio Sori, and Gomawo, quite clearly, NDC legal stalwarts are representing the petitioners. This is the unsavory part of the entire controversy that has caught everybody.
I mean, but to the bigger picture, if what you're saying, and indeed it's playing how you're seeing it, this does, whatever the outcome, this will do significant, possibly irreparable damage to the reputation of to the judiciary itself as an institution.
To the entire nation. To the entire nation that we have allowed today, this small constitutional matter of great national importance, to slide into an abyss of political mudslinging. And that is, not good for the image of the nation as a whole. So it's not only for the actors, but, the entire nation.
Is it too late to pull back now? I mean, the Chief Justice is asking for a few reliefs. And fundamentally, she wants this entire five-member body dissolved. She doesn't believe that it's the way to go, and reconstitute if you may, and that her suspension should be lifted. Should this process be truncated and a fresh committee set up to clean this up so we begin afresh?
Unfortunately, no. And quite regrettably, I disagree. I cannot go along with her leadership's interpretation of the constitutional process. The Constitution is quite clear. It has set parameters that must be followed. The President is only acting in accordance with the dictates of the Constitution. He has not violated any step in the process. All he has done up to date has been in accordance or in consonance with the provisions of the 1992 Constitution. I find it rather disturbing that the chief custodian of the Constitution, when it comes to interpretation, the third arm or branch of government, will rather take things to hold an otherwise legitimate and lawful constitutional process. You see, the entire edifice of Article 146 is deeply embedded in common law rules as well as principles, of constitutionalism. And that is, something that all of us must endeavor to uphold. I am not, for the NPP, nor for the NDC in this matter. I'm for the nation. What is good, for the public is what all of us should endeavor to support. This political, drama that is going on with the Chief Justice caught in the center of controversy is rather unfortunate for the nation. It brings us back to Shakespeare's Hamlet, to be or not to be. That is the question. So for the Chief Justice to descend into the arena of litigation herself, or to allow Godfrey Dame and fellow lawyers to do the legal battle for her, is what is now exercising her leadership's judicial mind. I would urge her leadership to confer with the Judicial Council, because that council was created to advise, counsel, and support the Chief Justice to behave herself.
But she's being suspended.
And avoid all these things.
I mean, she's being suspended. I mean, has she got any?
No, she has not been removed. She's only been, merely been suspended, and therefore she's still the Chief Justice. That is why we have for Bafu Boni in an acting capacity. For Bafu Boni is not a substantive Chief Justice yet. So her leadership, Gertrude Torkornoo, remains the Chief Justice of the Republic. Don't let us assume that because of all these ugly noises, the petitions are going to succeed. And that is why I consider the latest twist to be rather unwise and ill-timed. The Chief Justice shouldn't have descended into the arena of litigation. What he has done now, as I said in the afternoon, has rather been to shoot herself wrongly in the foot.
I mean, John Darku, what do you make of that? She shouldn't have stepped into the arena of litigation.
Well, I mean, I disagree with the learned friend of mine and my good old professor. I think that the Chief Justice is entitled to contest any position that she feels is going wrong. She believes, for instance, that this matter should be in public. I think it's a very fair view that she's taking, and it is only the courts, the Supreme Court, that can make that decision. For instance, she believes that Justice Puaman, who was one time, I think, the lawyer for one of the petitioners, Ofori, and became a judge and ruled in the matter, the same matter, the EcoBank matter. He became a judge, sat on cases involving the same person, and now is sitting as a chairman of this process. And the Ofori matter is one of the things that will be considered. He was once his lawyer. He has sat as a judge on the matter, and now this comes up again, and he's now going to chair. These are germane issues, and I think that it's fair for her to raise them. Look, at this point, for me, I believe that we have come to the point where we've seen that this is just the politics. And I'm surprised when I mentioned the fact that the president and his the party chairman had made this claim. My panelists have not denied that, especially my other colleague said that the president didn't say that. But did he also talk about what a Stephen Ketia had said? We have videos of a Stephen Ketia who has said that the chief justice ought to be removed and then followed by the head and the top echelon of the Electoral Commission. So it is the politics they are executing. So when Leonard Ansari said that the president hasn't done anything wrong and that he's acting in accordance with the Constitution, I laugh because you see, it is the politics clause in the Constitution. We need to be very careful as a country, and I'll be surprised if this remains. Let's say NPP is in power in 2029, and this same thing is being done. What will be the position of the people who are supporting the president now? We are moving into a slippery slope, and we need to be very careful as a country. Look, there's a reason why this particular provision 146 has never been activated, and I dare say that all the past chief justices, okay, none of them were saints. When it comes to administrative breaches, I believe all of them, one way or the other, breached an administrative provision. All right, but the presidents then never activated 146. We are destroying the independence of the judiciary under the cloak of 146, and I believe we need to be very careful.
Okay, gentlemen, I'm grateful that you joined me. Abraham Amaliba, thank you very much. John Darko. Yes, Abraham?
But how can the removal of one judge be an attack on the entire judiciary? This article...
But that judge in question is the Chief Justice. It's different, isn't it?
It doesn't matter. This provision allows citizens to participate in our governance system. This constitution is made for the people. And so this provision provides that petitioners who are Ghanaians can bring such a petition. And you say the president should overlook it. Then why is that provision there? The removal of one judge, although a chief justice, cannot in any way be seen as an attack on the judiciary. Okay. I disagree.
Amaliba, thank you very much. John Darko, grateful. I'm sorry to enjoy the rest of your evening.